Welcome back to the Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world.
Hey guys, it's totally realistic Adam, because John screwed up the script this week. And guess what? We're once again talking about New Jersey and a magazine ban. Yeah.
SB Tactical, the originator of the pistol stabilizing brace, set the bar for innovation and product development in the PDW pistol category. From the insanely popular SB-M4 to the adjustable SB-A3 and even kits for pump-action firearms, SB Tactical braces are available for a wide variety of firearm platforms in fixed, adjustable, and side-folding models. To get 15% off your legally transported and carried pistol braces, use the code TGC15 over at sb-tactical.com. Recently, the Third Circuit Court of Appeals handed down a 2-1 decision in which it upheld the district court's denial of a preliminary injunction to stop New Jersey's newly passed law, which cut down the law-abiding gun owner's right to have magazines which held 15 rounds to 10. We covered the details of the ban here and the district court's denial here. The Third Circuit began by asking whether a magazine was an arm under the Second Amendment. As we all know, magazines are devices that hold cartridges or ammunition. The court quoted the Ninth Circuit, stating that regulations that eliminate a person's ability to obtain or use ammunition could thereby make it impossible to use firearms for their core purpose. Because magazines feed ammunition into certain guns, and ammunition is necessary for such a gun to function as intended, magazines are arms under the Second Amendment. Finding that a magazine was an arm, the court then employed a 2-part test to determine whether the magazine ban violated the Second Amendment. In Step 1, the court examined whether the magazines were commonly owned and typically possessed by law-abiding citizens for lawful purposes. Finding that the record showed millions of magazines were owned, it determined that large-capacity magazines are typically possessed by law-abiding citizens for lawful purposes and that they're entitled to Second Amendment protection. In Step 2 of the analysis, the court determined that intermediate scrutiny was appropriate. How did it arrive at that conclusion? Well, the applicable level of scrutiny is dictated by whether the challenged regulation burdens the core Second Amendment right. Courts have stated that the core Second Amendment right is the ability of an individual to defend themselves within their own home, and any laws that burden that right are subject to strict scrutiny. Here, the Third Circuit found that the law did not severely burden that core right for 5 reasons. First, the law did not categorically ban a class of firearms. As stated by the court, the ban applies only to magazines capable of holding more than 10 rounds, and thus restricts the possession of only a subset of magazines that are over a certain capacity. Second, the law is not a prohibition of an entire class of arms that is overwhelmingly chosen by American society for self-defense in the home. The court acknowledged that the firearm at issue in Heller was a handgun, which was noted to be the quintessential self-defense weapon, versus large-capacity magazines, which the record demonstrated were not well suited for self-defense. Third, a prohibition on large-capacity magazines does not effectively disarm individuals or substantially affect their ability to defend themselves, because individuals still have magazines or could choose other firearms. Fourth, the law does not render the arm at issue incapable of operating as intended. New Jersey citizens, and this is a quote, may still possess and utilize magazines simply with 5 fewer rounds per magazine. Lastly, the court concluded that it cannot be the case that the possession of a firearm in the home for self-defense is a protected form of possession under all circumstances. Applying intermediate scrutiny, which requires the government assert an important interest and demonstrate a reasonable fit between that interest and the challenged law, such that the law does not burden more conduct than is reasonably necessary. The court determined that New Jersey's law was constitutional. Specifically, the court noted that large-capacity magazines allow for more shots to be fired from a single weapon, and thus more casualties to occur when they are used. And also that by prohibiting large-capacity magazines, the act reduces the number of shots that can be fired from one gun, making numerous injuries less likely. Finding that the law does not burden more conduct than reasonably necessary because it does not disarm an individual, the court found that the law survived intermediate scrutiny. The Third Circuit also rejected the takings claim, finding that no actual takings had occurred because owners had the option to transfer or sell their large-capacity magazines to an individual or entity who could lawfully possess them, or they could modify them to accept fewer than 10 rounds, or register those that could not be modified. With those alternatives, the court found that the law does not result in a regulatory taking because it didn't deprive the gun owners of all economically beneficial or productive uses of their magazines. Lastly, the court rejected the plaintiff's equal protection claim, finding that they did not show retired law enforcement officers were similarly situated to other New Jersey residents, and that the retired law enforcement officers had training and experience not possessed by the general public. Now, at the beginning, I did mention there was a 2-1 decision. So I know what you're all asking. But Adam! But Adam! What about that dissent? Well, I'm glad you asked. Judge BIBAS pulled no punches by starting the dissent with criticism of the majority's choice of intermediate scrutiny. He then argues that the majority didn't even use intermediate scrutiny, but rather rational basis, which is an even lower standard. The majority, quote, suggests that this record favors the government, but make no mistake, that is not what the district court found. The majority repeatedly relies on evidence that the district court did not rely on, and expert testimony that the district court said was of little help, end quote. Judge BIBAS noted that regardless of which level of scrutiny applied, real evidence that the law furthers the government's aim and is tailored to that aim is required. He criticized the majority for substituting anecdotes and armchair reasoning for the concrete proof that is demanded for heightened scrutiny analyses. Notably, New Jersey has introduced no expert study of how similar magazine restrictions have worked elsewhere, nor did the district court identify any other evidence, as opposed to armchair reasoning, that illuminated how this law will reduce the harm from mass shootings. He also argued that alternatives to this ban may be less burdensome and as effective. New Jersey has already gone further than most states. It has a pre-existing 15-round magazine limit and a restrictive permitting system. These laws may already do much to allay its public safety concerns. New Jersey needs to show that these and other measures will not suffice. He also stated he would apply strict scrutiny to any law that impairs the core Second Amendment right to defend one's home. He went on to say, this law does so, and it fails strict scrutiny. So what does all this mean? Well, as I mentioned in the beginning, this was only in relation to the preliminary injunction, which means that the district court still has to hear this case on the merits. The plaintiffs can either ask to have this reheard en banc, which is by the court as a whole, or appeal this decision to the Supreme Court, but that will only be in relation to the preliminary injunction. Be sure to check out the dissent in the opinion. It's down at the link in the description. That's all for this episode. If you learned anything from the show, help us out and hit that like button. Make sure you share it with your friends. Don't forget to get subscribed, and if you enjoyed the video, consider supporting us via the links down in the video description. Be sure to check out the Gun Collective podcast on iTunes, and as always, thanks for watching. Magazines are arms under the Second Amendment. I hope that was right, because I totally made that up. Similarly.
You gotta stop using words that you can't pronounce.
Similarly.
You wrote this.
I know. The shirts worn on today's episode were brought to you by...
The shirts worn in today's video on the Gun Collective have been provided by Patriot Patch. Closed captions have also been brought to you by Patriot Patch Company. Be sure to click the link in the video description to check out all of their great products, including their cleaning mats.